It is not in the financial interest of attorneys who profit from lengthy litigation to recommend a better and less costly system. They will only do so if they prioritize your best interest over their own. Hello, my name is Rick Grossman, and I am the founder of the nonprofit Intelligent Justice. In this video post, we will explore how traditional litigation lawyers feel about the advent of Intelligent Justice's comprehensive adjudication system. As I have explained in my past posts, the simple genius of our comprehensive adjudication procedure is that it replaces the inflated cost of each side paying separate lawyers to perform inefficient and duplicative work with half the cost of a single expert adjudicator who zealously seeks the law and evidence supporting the positions of both sides before deciding which side to the dispute legally deserves to win. For that reason, it is not in your lawyer's best financial interest to recommend utilizing comprehensive adjudication instead of hiring him or her to perform years of litigation work at your expense. After all, litigation lawyers make a boatload of money from charging their high hourly rates for endless evidentiary discovery disputes, procedural motions, court hearings, and duplicative legal research, document review, and presentations of the evidence. Now, all of that inefficiency is not their fault. They do what they have to do to win in a public court system that was designed for deciding legal disputes centuries ago. I know this to be true because I was one of those lawyers for several decades. But I also know that the inefficient and costly procedures designed for an arcane public court system may have been good for my bank account, but they were not particularly good for my clients, even when I won cases on their behalf. And that is why I founded Intelligent Justice, to design a system for deciding legal disputes that is far better for the parties involved in the dispute. Now, even though it is not in their personal financial interest to do so, lawyers that truly care about their clients' best interests will recommend exploring the possibility of utilizing comprehensive adjudication to decide their legal disputes because it costs nothing to jointly interview adjudicator candidates and determine the expected timeline and capped cost of an adjudication upfront. It also costs nothing to determine whether you and your adversary can agree on the selection of a distinguished, neutral adjudicator to investigate and decide your dispute. As you will learn in an upcoming video post, it is always a strategically intelligent move to explore the use of a comprehensive adjudication, even if your adversary ultimately declines the opportunity to join you. But lawyers who care more about their own financial interests will recommend against using a comprehensive adjudication and come up with some pretty lame excuses for that recommendation. Some uninformed lawyers will say that comprehensive adjudication is unproven, even though, as I have explained in a prior post, the procedure has been used successfully in other advanced democracies for decades. Other lawyers will argue that you are better off having an advocate involved who will emphasize the law and evidence that favors you, even though there's no data to support this argument, even though experienced litigators know that any advantage to having a legal gladiator in your corner is usually neutralized by your legal adversary having an equally skilled gladiator in their corner. And while it may be emotionally comforting to have an advocate who only emphasizes the arguments that favor you, the emotional comfort is rarely worth the extraordinary additional financial cost required for traditional litigation. Now, that said, there are ways that your separate counsel can participate in a comprehensive adjudication proceeding on a controlled basis for a minimal additional cost, if that is more comfortable for you. In my next post, I will explain how your separate counsel can add some value to a comprehensive adjudication without erasing its primary cost-saving features.